Hey guys, Todd Vandermide back here for Freedom Still, your former NRA contract lobbyist and all around Illinois gun law guru. Um, got a ton of stuff on the docket. Today's video is going to be about 2A pitfalls. Now, you may be seeing a couple more videos today, depending on my workload, dealing with litigation and some other stuff. Got a ton of stuff in the stack of stuff, as Rush Limbaugh used to call it. And it keeps getting higher and higher that I'm trying to get through. So we had a couple of really good decisions last week. The Fifth Circuit Court of Appeals in New Orleans ruled 922 G8 unconstitutional for civil orders. And Oklahoma court ruled that 922 G3, the prohibition on marijuana users, was unconstitutional. And people have been reporting on those other YouTube channels, have been talking about these decisions, and they're right. They're good decisions. I think they're missing the point. Throughout all this, in light of the New York decision, we now have what I call the 2A pitfalls, the arguments that we must address and beat down. We must drive a stake through the heart of these as if they're a vampire and a Bram Stoker novel. And we just have to pound these into submission in our court filings, our briefs, and our arguments. And yes, that pun was intended. So let's get through this stuff. I want to talk to you about the 2A pitfalls because I think what these decisions are doing are laying out a roadmap for us to beat back what the government keeps offering up. So the first one, law-abiding citizens. This comes from a quote in Heller. It's at the tail end of my favorite quote about, we don't know the other enumerated right subjected to a freestanding interest balancing approach. But the tail end of that, I think it's on page 64, Justice Scalia says, and whatever else it leaves to future evaluation, it surely elevates above all other interests the right of law-abiding responsible citizens to use arms in defense of hearth and home. And so from that, the other side has been trying to bootstrap up this argument that the Second Amendment only applies to law-abiding citizens. And they keep harping on that in their briefs. They harped on it in the Range case. They harped on it in the oral arguments in the Atkinson case. They've said as much in the GSL challenge to the FOID card here in Illinois. They keep going on and on and on about this, trying to take one sentence out of the Heller decision and then somehow make it into this mountain of what it's not. And they're trying to clutch at every straw, every string, every thread they can in doing all this. And with that, they keep going that it's law-abiding citizens. And they point to founding era laws that prohibited Catholics from having guns, Quakers, Puritans, people like that, on religious grounds. And then they point to laws that barred slaves. It's almost as if they want the Dred Scott decision to come back. And then they turn around and they point to Native Americans were not allowed to have guns back in the day. And they use those as, that's part of the tradition and history of our nation in prohibiting people from having guns. No matter how wrong-headed it is, that's what they're staking their claims to. And these judges in these cases are doing a really good job. And lots of people are talking about these cases, but I think they're missing the big point. The real point is how these judges are putting down stuff. And so when the anti-gunners say it's only law-abiding citizens, well, let's remember, even if you're a convicted felon, you do not lose your First Amendment right to free speech, freedom of religion, whatever. Even if you're a convicted felon, you do not lose your ability to refuse warrantless searches. The government still has to have a warrant if they want to search certain things that are outside the public view doctrine or whatever those are with a Terry stop or whatever else. They don't get to come into your place of business, your car per se, other things like that, just because. They haven't lost their Fifth Amendment rights against self-incrimination, all those things. So in the Oklahoma case dealing with users of marijuana, the court dealt with this upright. It said, moreover, the Supreme Court has held that the people unambiguously refers to all members of the political community, not an unspecified subset, further explaining that the term refers to a class of persons who are part of a national community or have otherwise developed sufficient connection with this country to be considered part of that community. The court thus concluded that there was a strong presumption that the Second Amendment right to keep and carry handguns publicly for self-defense belongs to all Americans. These are the pitfalls of the 2A that we have to mitigate. We have to put down. We have to beat back early on because this is all the government has. In common use is another one. And so now the anti-gunners, and we've seen this in the Bianchi case in Maryland, we've seen it in the Naperville case, we've seen it in other cases where they are trying to argue whether or not AR-15s, they're going model by model. And in this pitfall, and they said so in the Bianchi orals, that they wanted to go through their entire list in the Maryland law and contest whether or not each individual make and model was actually in common use. Now we have the Catano decision where Justice Alito said 200,000 stun guns was enough. But they're going to try to make this a percentage of guns, percentage of people in the United States who own these guns. They're going to make all kinds of crazy arguments. And that's why they're starting to try to push back against the Catano decision, which kind of gave us a baseline number of 200,000. That potentially if there are 200,000. Now, I would point out that it's not 200,000 of a specific make or model. Remember, in Heller, it said handguns. Didn't specify revolvers, Glocks, Derringers. It said handguns, a category of firearms. And so, Justice Scalia masterfully dealt with this in Heller when he wrote, some have made the argument bordering on the frivolous that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Boom. That is our beginning, middle, and end when it comes to this, outside of using Catano. And we need to beat it back because these are the games they're going to play. And we have some other references to in common use, and we'll get around to dealing with all that. Like I said, I'm going to take all these apart one by one and do a video on each of them. Dangerous or unusual is what they are trying to claim. Yes, I know that's wrong because Heller said dangerous and unusual. And now in these court arguments, they are making these really nuanced arguments of unusually dangerous, trying to merge the terms. And so their argument is that there's a footnote in Heller that cites Blackstone. And Blackstone said dangerous or unusual. And now you had the court in Heller say dangerous and unusual. And they're trying to turn that on its ear. They're trying to change that conjunction. And, maybe I need to put the Schoolhouse Rock video up all over again. But that's another one that they're doing. And then, and that's going to take a longer video. Then the other one is in the home. This has been one of my pet peeves from the beginning, from the very beginning. They have omitted, just like they're changing and to or. They have ignored, shielded their eyes from, and just plain left out two words, such as. In the opening part of Heller, under the holdings, what the court says, these are what we find. The first holding is the Second Amendment protects an individual right to possess a firearm unconnected with service in the militia and to use that arm for traditionally lawful purposes, such as self-defense within the home. See, for all those years, they were trying to say Heller only applied to handguns, Heller only applied to self-defense, Heller only applied to in the home. They are trying to make those three, they're trying to add each of those, stack them up to where that's all Heller ever said. And New York clearly disproves that. Catano disproves that. And so they have ignored such as self-defense within the home. Self-defense was but one of the traditionally lawful purposes Heller said you had a right for, whether it's collecting, target shooting, practice, competition, hunting, whatever. All those lawful uses are contained and protected under Heller, and it's the government's burden, not ours, their burden, to prove under the test that the text of the Second Amendment does not protect the conduct, that the conduct is such that there is a history and tradition of regulating that to such a degree that the now challenged law is constitutional. So those are the pitfalls of the Second Amendment that we need to attack each and every time. And as these courts do a masterful job of tearing these arguments down, we should be highlighting those, we should be incorporating those, and we should be taking that reasoning and force-feeding it to the other side. Like I said, my goal at this point in time is to force-feed them a healthy dose of Heller and New York, and I'll even provide the Tabasco sauce, and I hope they choke on it because they're making all these bullshit moves about how they're trying to grab a phrase here or turn a word there because it's all they have left. Now, we'll see what Justice Thomas, Alito, and the rest of them have to say when some of these issues get up in front of them. And we'll see what kind of splits in the circuits we're going to have on this. I would wager that the Second Circuit right now thinks they are the vanguards of the old liberal line on this. We'll see what the Ninth Circuit does when we get a bunch of rulings out of Justice Benitez's court, and we'll see where it all goes. But guys, that's this 15-minute video on the pitfalls of the Second Amendment. When you read these court decisions, look for these topics. Look how the court deals with these topics, and that will tell you how and where we need to structure our debates going forward. So as always, hit the like, subscribe buttons, hit the notification bell so you know when we have new videos coming out. We really appreciate everybody that's been subscribing and getting us closer to that 7,500 mark, and we're going to reach out for 10,000 subscribers after that. We are working on some merch and some stuff like that to get moving. Got a lot of stuff in the fire these days, lots of irons going on. And as always, we appreciate, thank you, your shout outs, your support, your comments. We try to respond to them. And as always, guys, frag out.